there's no substitute for really hard work. Knowledge really is power. And when you're given a case, if it's litigation, if it's drafting a contract, realize that contracts are nothing but checklists. When I had a young associate, I'd usually start them off on, for example, a purchase and sale agreement for real estate. It's the simplest sort of transaction. And I'd have them write it, and they'd bring it to me with their draft, and then I'd start to go through them, and I'd say, why'd you put this section in, or why didn't you take this section out? And very often they'd say, well, you know, it was in your standard form. I said, well, you know, if I needed someone to fill in my standard form, I don't need you. I can have my secretary do that. I hired you for your brains. It was just a little bit of a tough lesson, but you know, you give tough love, and then I explained to them at the end. Every first-year associate does this, so don't worry about it. But just don't do it again. Ask questions. Why did you put this in? What does this mean? Well, I don't understand this provision. Most lawyers like to teach, and take advantage if you're in a small or medium-sized firm or a large firm. Find a partner as a mentor and have him or her work with you. When a case is over, post-mortem it. Be a sponge. I have to tell you, I learned so much more, not only from doing that with the lawyer, but also try to expose yourself to the best there is. One of the benefits of being in a big case is usually they have really tough, good lawyers on the other side. And having had the tar beaten out of me by some of the finest lawyers in the country was very, very good for me. I wasn't happy about it at the time, of course, but you know, it steels you for dealing with the crucible, because in tough cases you have to have ice water running through your veins, and you have to be calm because it's natural to you, not because I have to stay calm. You need to focus on the means, not the ends. The courses that I took in law school were the courses with the best professors. They weren't necessarily the subjects that I wanted. The method will serve you well in whatever it is that you do. So focus, a pitcher can't throw strikes. A pitcher's got to focus on his breathing, his body mechanics, his muscle memory, his rhythm, and the strikes will come. If you're worried about how the partner's going to perceive you instead of doing your job for your client, which is natural to all of us, you're going to have an inherent conflict of interest. How are you perceived? If you simplify your job by just trying to do it, and believe me, I've made an ass of myself more times than most people in the world, and you live. And if you don't make mistakes, you haven't learned anything. So you really need to discipline yourself on your focus. Use the scientific method. Try not to prejudice your research by the outcome that you want to achieve. Sometimes you have to give partners who tell you to research an area of the law the bad news. Although if you're stuck, come and talk to them about it before you spend hours writing a memorandum and find out that you've chased a rabbit trail the wrong way. Because if you have to write an advocacy piece, that's fine, but first start out knowing what the law is, because if you go into court saying black is white, you'll lose your credibility, and soon the judges will know that that's what you're doing.